If the COVID pandemic were to surge out of control so that there were more patients coming to our hospitals needing critical medical care than there are beds, ventilators, and doctors to provide them with the medical services they need, how do you decide which patients to refuse the care they need and which will get the care they need? My name is David Lepofsky. I'm a visiting professor at the Osgoode Hall Law School. I'm also the chair of the Accessibility for Ontarians with Disabilities Act Alliance. This is the issue of critical care medical triage, or rationing. It hasn't yet arisen in Ontario, and we hope it never will, but we need to be ready in case it does. In this lecture, I'm going to explore this issue from the legal perspective of disability rights and the rights of patients with disabilities. Now, what do I know about this subject? I've been involved in advocacy on it in collaboration with a number of superb advocates and experts from the disability perspective over the past few months. Before that, I served from 1994 to 2005 leading the campaign as the chair of the coalition that fought and won the enactment of the Accessibility for Ontarians with Disabilities Act. I now lead the coalition, its successor, that campaigns for its effective implementation. For at least a decade, I've been involved in leading our efforts at getting the Ontario government to create and enact a healthcare accessibility standard to ensure that our healthcare system is fully accessible to patients with disabilities. And during the pandemic over this summer, I, as part of my activities working together with other advocates in the disability community, took part in consultations with the provincial government's bioethics table that was addressing this issue. More about that as this lecture unfolds. Just a note of credit, I want to thank an amazing team of Osgoode Hall Law students volunteering for the AODA Alliance for their Osgoode Public Interest requirement who helped with research in this area. And I want to thank particularly the lawyers at the Arch Disability Law Center who have been doing excellent work leading this campaign, and my colleagues Roxanne McKittiuk, professor at Osgoode, and Trudeau Lemons at the UT Law School, who've worked collaboratively together as we tried to come up with solutions on this important issue under incredible timelines and under deep stress about how this issue might unfold. Over the next few minutes, what I hope to do is to outline for you the events as they've unfolded this summer on this issue, and to explain the concerns that we have attempted to raise in how the Ontario government has been addressing this issue. I'll then offer some concluding thoughts. I want to explain at the outset that we are not talking about the medical question of who needs critical care. We're assuming that if there are patients who are medically adjudged to need critical care, but there aren't enough beds, doctors, or ventilators to provide that care, a decision would have to be made, an awful decision over who would get it and who would not. But the starting point is that all those who would be subjected to this decision are patients who need critical care, care which is insured and covered by our public health insurance system. This lecture is up to date as of November 4th, 2020, but events are unfolding, so things could well change after today. Before I dive into the chronology of the events, let me just talk briefly about the legal principles that I would say clearly apply here. First, patients with disabilities, or indeed all patients, would come to hospital in this situation seeking medical care, which is insured by our public health care system. So they start out from the premise that they have a right to this, and indeed the universal health care system we have is one that Canadians have for a long time considered a fundamental right in our society. Section 15 of the Canadian Charter of Rights and Freedoms, part of our Constitution, guarantees equality to all, including equality free from discrimination because of a disability. Disability is broadly understood, as is the right to equality. It would apply here, since our healthcare system is one which our Supreme Court in the Eldridge versus BC case held almost a quarter of a century ago, is one in which patients with disabilities have a right to equality free from discrimination because of disability. Similarly, human rights legislation such as the Ontario Human Rights Code guarantee a right to equal treatment with respect to goods, services, and facilities without discrimination because of disability. And that involves a broad definition of discrimination and a broad definition of disability. Healthcare services, and certainly critical care healthcare services, would most certainly be covered as a service or a facility under human rights legislation. The Accessibility for Ontarians with Disabilities Act that I referred to earlier requires the provincial government to lead Ontario to become fully accessible to people with disabilities. Again, disability very broadly defined to include physical, mental, sensory, intellectual, communication, learning disabilities, and many others. It requires the province to lead us there by 2025, and that includes accessibility in our healthcare system. And finally, the common law duty of fairness requires that, especially with respect to decisions over fundamental rights, like the right to life, one is entitled to, and one would here include a patient, is entitled to a fair process, a notice and an opportunity to have their perspective heard before a decision is made that could fundamentally affect them. This echoes the requirements equally applicable of Section 7 of the Canadian Charter of Rights and Freedoms, which guarantees to everyone the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Fundamental justice includes, among other things, a fair process. Well, let me turn to the chronology of unfolding events. Last February, as the pandemic was starting to rear its ugly head potentially here, or fear that it would be reaching us soon, the provincial government apparently decided that it would be worthwhile to develop some kind of protocol to address medical triage decisions in the critical care context. It did not make this decision public. It appointed a bioethics table, or chose a bioethics table, of doctors and bioethicists to develop this protocol. That table did some work. It may have consulted within the healthcare community, but it certainly didn't consult the public. In fact, we didn't know they were doing any of this. They certainly didn't consult people with disabilities. And they developed a protocol which the government of Ontario sent to all hospitals. Its branch called Ontario Health apparently did this, sent to all hospitals. This protocol, this critical care triage protocol, was dated March 28th, 2020. It was not made public. To this date, it has not been made public by the government in any formal or official way. It was sent to all hospitals, again, without telling the public it was doing so. Within days, the existence of this protocol was leaked to some within the disability community, and under the excellent leadership of the Arch Disability Law Center, did an excellent job of bringing together concerned folks, including the AODA Alliance, and proposed an open letter, which was made public on the 8th of April, an open letter to the government raising serious concern that this protocol discriminated against patients with disabilities. The day before, on April 7th, this issue was first made public by the executive director of the Arch Disability Law Center, Rob Latanzio, during the first virtual town hall on COVID and disability issues that was convened by the Ontario Autism Coalition and the AODA Alliance. I co-anchored that event. So it was made public. The concerns were made public on April 7th, and on April 8th, the open letter to the government, co-signed by a number of disability organizations, was made public. On the 14th of April, just days later, the AODA Alliance made public a discussion paper raising ideas of what should be properly included in such a protocol, seeking input from the community. No one in the months since we made it public has objected to a word in it or said that we got anything wrong. By the way, these events and the documents related to them are all available on our website at aodaalliance.org/COVID. On the 21st of April, just about a week later, the government of Ontario made an announcement. They said that this protocol was only a draft and the government agreed that they would consult with experts in the community and in the human rights sphere on what it should provide. Now, by the way, this claim that it was marked as a draft, from what we've been told, it was not marked draft. And the document, I got to tell you, from my experience working in government for a third of a century, when the government has a sensitive document they want treated as a draft, it marks it very clearly as a draft. In any event, this was a helpful step. However, we and others called on the government to rescind this document if it's only a draft. The government did not do so. It has not done so to this day. On the 13th of May 2020, the Arch Disability Law Center released a detailed and excellent analysis of the critical care triage protocol, the March 28th one, the supposed draft, which they had seen, and which they documented the ways in which it raised serious disability human rights concerns. In June of 2020, the bioethics table reached out to some within the disability community through the Ontario Human Rights Commission. They sought to have a group of disability advocates and experts consult with the bioethics table. Among those organizations invited to take part and which played a leadership role were the AODA Alliance and the Arch Disability Law Center. And as well, we were ably assisted by Professors Roxanne McKittiak and Trudeau Lemons, who I referred to earlier. Over the summer, we held a number of very constructive virtual meetings with members of the bioethics table. We asked a lot of questions, we asked for a lot of information, and this information helped us formulate our thoughts and organize our views on what they were proposing. As well, the bioethics table during the summer gave us a revised draft of the protocol that had been written sometime after the original March 28th protocol. They gave it to us on an understanding that we could make it public, and the AODA Alliance posted it on our website on July 16th, 2020. And it was on that document that we were giving our core input. Our process of giving input culminated on the 31st of August. And during a meeting of about an hour, a virtual meeting, we made our final presentations of our concerns. The Arch Disability Law Center made a presentation. I then did about a 20-minute presentation for the AODA Alliance, and then we had a back and forth discussion. Linked to this video is the video of the 20-minute presentation that I made to the bioethics table. In conjunction with that virtual meeting, the AODA Alliance submitted a 20-page detailed written submission to the bioethics table, available at the link I gave you earlier. And 2 days later, on the 1st of September, the Arch Disability Law Center did so as well. We endorsed each other's submissions and worked together to collaborate to present a common front on the concerns we raised. More about what we had to say in just a few minutes. After that, our discussions with the bioethics table were completed, and we were later to learn that the bioethics table formulated its final report and recommendations and sent them to the government. On the 11th of September 2020, they sent it to Ontario Health, part of the government. On the 14th of September, they sent it to the Ministry of Health. And sometime around then, they also submitted it on a confidential basis to the Ontario Human Rights Commission. We have not seen it. It has not been made public. On the 25th of September, I wrote the Minister of Health, Christine Elliott, on behalf of my coalition, urging the government to immediately withdraw or rescind the controversial and widely condemned March 28th protocol, the supposed draft protocol that was still out there. The Human Rights Commission and other community organizations had also called for it to be withdrawn. It still hasn't been as of the day I'm recording this video. We also asked the government to make public the recommendations of the bioethics table and to consult us all on it. As of now, they still have not done so, nor have they agreed to. In fact, in subsequent media interviews with the Toronto Star and Radio Canada, the government specifically refused to disclose those recommendations. Leading up to the date when I'm recording this, on October 16th, 2020, the government's own flagship human rights agency, the Ontario Human Rights Commission, wrote the Minister of Health Their letter was not made public till 2 weeks later, but it has been made public now. In it, the Human Rights Commission called on the government to, as I've said, make public the report of the bioethics table and indicated that the bioethics table had itself recommended this. The Ontario Human Rights Commission repeated its call for the March 28th triage protocol to be withdrawn and indicated that the bioethics table had also recommended this to the government. Remember, the Human Rights Commission has seen those recommendations to the bioethics table, even though the rest of us have not. The government has not responded to that letter as far as we've seen. So on November the 2nd, I again wrote the Minister of Health urging her to follow the recommendations of the Human Rights Commission from us and from their own bioethics table, make these recommendations public, rescind the March 28th protocol, and work with us on developing its replacement. That's where we are as of now. So what are our concerns? Well, let me begin by just describing what the revised protocol includes that's particularly important, or what it's missing. And from our understanding, these are equally replicated in the original protocol, the March 28th one that precedes the revised draft that we made public on July 16, 2020, and on which we were commenting. The protocol contemplates that if there is a surge whereby there is an overflow of demand that exceeds supply for critical care, there are different levels of triage that would be, or degrees of triage that would be needed and that would be centrally determined. But if triage is triggered, and I have to again emphasize, it hasn't yet been triggered, and we don't know if it ever will be. We need to be ready in case it is. But in any event, if it is triggered, then a triage decision would be made along these lines. What does the triage protocol provide? Well, first, if a patient needing critical care has less than 6 months to live anyway, they would be triaged out. Of those who have more than 6 months to live, if they have a progressive disease, then they would be assessed by a doctor on what's called the Clinical Frailty Scale, CFS. I'm going to have a lot to say about that over the next few minutes. And depending on their scoring, they could be triaged out and denied critical care. So how does that clinical frailty scale work? Well, as the bioethics table explained to me, a doctor would assess a patient, that's a patient who needs critical care, and they would determine if they have a progressive disease, and if they do, the CFS is applied to them. And what the CFS requires, in order to assess their likely mortality, their frailty, the doctor would assess whether the patient can do 11 different activities of daily living without assistance. They've got to be able to do these things without assistance, and their score will depend on how many they can do in the doctor's assessment. What are those 11 activities? Dressing, bathing, eating, walking, getting in and out of bed, using the telephone, going shopping, preparing meals, doing housework, taking medication, and finally, handling their own finances. These are not medical questions, but these are things a doctor would assess, and depending on how much or how little you can do, that's your score, and that affects whether you are triaged in or triaged out. So what are our concerns? First, we were deeply concerned from the perspective of the rule of law. Decisions over life and death, over whether you will be refused a publicly insured critical medical care service to which you are entitled and which you undisputedly need, those decisions have to be made, if they're denying them from you that service, in accordance with the law. Here, they would be governed by what is now still supposedly a draft protocol. It's just a memo. It's a memo written by advisors on a bioethics table and then sent to hospitals by some anonymous or unknown government official somewhere in the government bureaucracy. We raised the serious concern that doesn't meet the requirement of being properly legally authorized. The government hasn't shown that it has lawful authority to decide these matters with a memo. Put in its starkest, if God forbid triage had to happen and a patient was refused critical care they needed and they died, if the hospital, the government doctor were all sued, and if the defense by the victims, the patient's surviving family, and I guess you'd call them a victim in this case, and if the hospital or the doctor tried to say, well, we were following this letter from the government, the obvious question that would be presented, well, letter from the government's not a law. Where's the legal authority to do this? So that was the first serious concern, and that's one which the Human Rights Commission echoed in its correspondence with the government that was made public just days before my recording of this lecture. A concern that there has to be a proper legislative mandate for any decisions in this area. And the second concern we have is that whatever standard or criteria are to be used, the burden of proof is on those who are proposing it or implementing it to justify it, because it bears on the right to life, because, as I'll describe later, it raises serious disability human rights concerns. Well, what do we know about this? Because we're not satisfied, and I'm certainly not satisfied, that burden of proof has been met. The CFS was not created for the purpose of clinical triage. It was actually created to help assess patients to decide what care they do need, not what care they need, but should be refused. We were told last summer by the bioethics table that this CFS has never been used before for triage purposes. So those who would try to justify it would have to justify using it for the first time. It has not been tested as a triage tool. Remember, life and death considerations, there's no objective evidence that it is effectively deployed for that purpose, when used for that purpose. Next, it would need to be established not only that it's theoretically justified, but also that as a practical matter, that when it is used, different doctors will give the same or substantially the same assessments of the same patients. If there is significant subjectivity or even modest subjectivity in how different doctors would apply it, it could become very arbitrary and therefore not be justified as the criteria to be used. And in that regard, one of the leading doctors on the bioethics table, to whom we spoke, Dr. James Downer, who played a central role from what we understand in this, openly acknowledged that there is subjectivity in the CFS in how it is applied. Additionally, this burden of proof is not met because from our understanding, from what we learned from the bioethics tables, doctors are not required to learn how to use the CFS or to apply it when they're in medical school. We were told that some geriatricians would know about it, but there are doctors out there who don't know it. There's no requirement in the protocols we've seen that the doctors or whoever applies the CFS should actually be trained in how to use it. We also raised the added concern that doctors, by definition, aren't necessarily the profession that know how to assess one's ability to do activities of daily living. That's more of the work of occupational therapists. Now, beyond all of those concerns, the Arch Disability Law Center, in their written submissions and their oral submissions, did a superb job of reviewing the studies that the bioethics table gave us, supposedly justifying that the CFS provides an accurate, evidence-based measure of a patient's likely mortality. Your ability to independently do those 11 activities is somehow a good predictor of your likelihood of dying when you're at the stage of needing critical care. And what the Arch Disability Law Center said, and we endorse this, is that those studies don't actually support that conclusion for the full spectrum of people from age 18 and up that would be covered by the protocol. It might cover some of the older patients to some extent, but not support all of those to whom it would be applied, or many of those to whom it would be applied. So for that reason, the burden of proof was not met. And we suggested, and I think this is a really important point, it's not good enough for someone to turn to us and say, well, what would you use? We're not the experts in these kind of decisions. And it's no defense to an either illegal or unconstitutional or discriminatory or inappropriate practice of any sort to say, well, it's going to be used even if it has any of those or all of those problems until and unless you come up with a better one. That's not a justification for discrimination or other unfounded or inappropriate activity, especially in relation to something as fundamental as the right to life. The concerns I've already identified are themselves enough on their own to be fatal to this approach to making these triage decisions. But sadly, there's more that's wrong with it. The next major concern, to which I've adverted earlier, and I want to explore in greater detail, is that the clinical frailty scale applied here as proposed would be discriminatory against patients because of their disabilities. Now, discrimination can occur whether or not those adopting it intend it to be discriminatory. It doesn't have to be discriminatory on its face, but I would suggest that it is discriminatory on its face. Whether one could do that list of 11 activities or some of them is focusing on, it's pretty much a proxy in significant ways for disability. That's not to say only people with disabilities would have those issues, but they are among those who would obviously be affected by it. But even if we didn't consider it facially discriminatory based on disability, it is. Clearly there's disproportionate impact on people with disabilities to use such a requirement. That is especially so where the requirement is to assess the abilities of an individual to do these activities of daily living independently or without assistance. Well, disproportionately, some people with disabilities, some patients with disabilities will need assistance with some of those activities. And to evaluate their abilities without assistance, without accommodation, is inherently itself discriminatory. How do we know that? Because Supreme Court of Canada case law has made it clear for years, indeed decades, that the duty to accommodate people with disabilities in relation to activities covered by human rights codes and the Charter of Rights is itself central to the guarantee of equality to people with disabilities. So to evaluate their ability to do these tasks while denying them accommodations they use or need is inherently itself also discriminatory in a fundamental way. I made a couple of points during our discussions with the bioethics table that I think drive this message home particularly well. You would never ask a doctor or lawyer to remove their eyeglasses and then we will evaluate how good they are at doing their job, either as a surgeon or a lawyer in a classroom or a courtroom. And because we expect them to be able to have that assistance to be able to fairly assess what they could do. It would similarly be inequitable to make decisions, life and death decisions, over a patient with a disability in relation to these activities by similarly removing the assistance that they might otherwise need. And as well, whether one is able to do those activities without assistance may well be contingent on issues like access to prior rehabilitation and access to income. It actually will have a disparate impact on people who are poorer, who are disadvantaged, and so on. I'm a blind person who's been blind for 40 plus years, and I've had, fortunately, access to incredible technology, rehabilitation training, white cane training, and so on. Others, sadly, have not had the same opportunity. I might be able to do some of these activities more effectively than others. It's really arbitrary to distinguish between them and me based on, in terms of access to the right to live, taking that into account. As well, I indicated to the bioethics table, drawing on my own personal experience, as I said, I've been blind for over 40 years. If any of them were sighted and suddenly went totally blind, they would not be able to do any of the activities, I would believe, in the 11 that I listed safely. In fact, if nobody assisted them the moment they went blind and forward, they wouldn't be able to find their way around anywhere, find something to eat. They would be in a highly vulnerable situation. Does that mean that we treat them differently than me under this scale? Or must we all be painted with the same unfair brush? Either way, it's just totally inappropriate. Now, I said earlier that one of the lead authors of this protocol acknowledged that the clinical frailty scale has subjectivity built into it, as would be obvious just from looking at it. This has a special meaning or concern in the human rights context. See, one of the worries is, and significant worries from a disability perspective, is a doctor called upon to make one of these horrible decisions, which we openly acknowledge doctors don't want to have to ever make. It's not why they went to medical school, but that they may well make those decisions based on other suppositions, based on their own evaluation of what's the quality of life living with a disability. Maybe it's not as valued a life to experience as somebody without a disability, or to evaluate us based on our social utility. Maybe some other people have more to offer society if they live than someone with a disability might if they live. I'm not trying to characterize all doctors, but some could be prone to those kind of perceptions, just like others could be. And it's vital that they not be part of this decision under any circumstances. But to the extent that the test to be applied has the kind of wiggle room or subjectivity into it, in it, that the CFS has, that risks those criteria creeping in a way that we would never know, would never be able to document, and yet they could end up founding discriminatory decisions. This is a matter of deep concern. Finally, from the human rights perspective, one exchange that I had during these meetings, which I focused on, but I thought was really important, is I asked one of the members of the bioethics table, Dr. Downer, to whom I referred, and whether they would justify using race as a basis for making triage decisions if the data showed that different folks differentiated based on their race had different likely mortality rates. Now, I'm not advocating for using race as a criterion, and I'm not by any way suggesting that anyone at the bioethics table would condone it or would tolerate it. So I'm not trying to imply anything awfully about myself or about any of them. I just want to put the question. And Dr. Downer, to his credit, said the data wouldn't support using race, but in any event, even if it did, he wouldn't use race or gender as a criterion. Credit to him for taking that position. I agree with that completely. But here's the thing. Race is protected under human rights and the Charter. So is gender and sex. But so is disability. And if one criterion is inappropriate as given its human rights protection, so indeed if two are, the third should be as well. It was our view, in fact, it was echoed by all of us, I believe, at various points from the disability perspective, the CFS should have no role to play in these decisions. One possibility that was put to us is that it could be just a factor that would be weighed in a physician's decision. And our response was, that no, because as long as you say it's a factor, that means it would be open to a doctor. A doctor would have a sweeping, undocumented discretion to decide how much of a factor. We'll weigh it a lot for one patient, but not a lot for another one. Indeed, deciding how much weight it gets could be another opportunity or another avenue by which those kinds of concerns that I raised earlier, evaluating the quality of life of the patient, evaluating the social utility of the patient or perceived social utility, that those might creep in as a basis that is going to covertly govern or even unconsciously govern the doctor's decision. The next concern that I and others raised with the revised draft protocol that we made public on July 16th, 2020 for medical triage is that it did not include the safeguards that the AODA Alliance's April 14th, 2020 discussion paper emphasized as being central and, as I indicated earlier, no one has since objected to. Now, I invite you to take a look at that document in greater detail at aodaalliance.org/COVID. Just search for discussion paper. But among the concerns that we raised there are ones I've already adverted to. The triage decision should not be made based on a doctor's assessment of the quality of life or perceived quality of life of a person with disability or perceptions of their social utility as compared to people without disability. As well, decisions shouldn't be made based on what kind of burdens a doctor might think a patient with a disability might make on society if they survive compared to the burdens that others might make on society or their need for accommodation or any such things. I invite you to look at the discussion paper for a broader spectrum of thoughts that we constructively offered there. Here again, I'd say that these additional concerns, all of the concerns I've listed, are ample to jettison the protocol, but sadly, there's still more wrong with it. The protocol that we reviewed was substantially lacking in any fair due process for patients that might be exposed to triage decision. Now, that due process is inherently needed pursuant to Section 7 of the Charter of Rights, the right to life, liberty, and security of the person, and the right not to be deprived thereof, and except in accordance with the principles of fundamental justice. I think you could also support it with the equality rights guarantees and the Charter and human rights codes. It's also fully necessitated by the common law duty of fairness that I referred to earlier. What kind of protections are there in the protocol that we saw? Well, really none. Basically, a doctor would assess you. They would then ask another doctor for a second opinion and then give you the bad news if the news is bad. And thered be no appeal. This is wrong on multiple fronts. A patient should be given early notice, the earliest opportunity, that they might be subjected to triage. They should be given rights advice so that they can seek assistance and protecting their own life in this process. We raised concerns before the bioethics table about who makes these decisions. The assumption was it's a doctor. But we raised the question here whether this is medical or purely medical at all. This is not a decision over what your medical condition is. This is or what medical treatment you need. This is a decision over who among competing patients would get access to scarce government-funded resources. And so we raised the possibility that we opened the discussion that it needs to be a broader discussion over who makes the decision. And at least it should be a broader group than just a physician. And we suggested other professionals who might be brought into the discussion, recognizing that it has to happen quickly. It is also important, and the bioethics, the triage protocol that we saw did not include any protection for this, that there be no conflict of interest on the part of those making these decisions. So that, for example, if there are different patients seeking access to a scarce bed or ventilator, a doctor who is related to some of them or friends with some of them shouldn't really be involved in a decision over who gets and who doesn't for obvious conflict of interest reasons. There should be a requirement of training for those making these decisions so that they are skilled at using the protocol, whatever the criteria may be. Fundamentally, the patient should have a right to input into the decision. If the question is, are they able to undertake certain activities of daily living, if the CFS were to be used despite its serious problems, then the patient should have an opportunity to prove they can do those activities, not simply find out that some doctor evaluated them and guess what, they think you can't. As well, there should be a right to a speedy appeal, recognizing that these decisions have to be made rapidly under difficult situations, conditions. This isn't something that can be protracted over a long period of time. Indeed, we suggested ways that this could be expedited. First, the case could be reviewed by a second triage team that had nothing to do with the initial decision, and not being briefed on the initial decision, the patient should get the benefit of whichever is the most favorable of the two teams' assessments. There should then be an opportunity for a rapid appeal to either the Consent and Capacity Board or to a court on a very, very expedited basis. And the government should ensure that there is legal aid services available for the family and the patient so that these kind of proceedings or discussions can happen over a very, very short accelerated time. That would require a specialized team to be trained and ready to go as soon as they are needed. Finally, overseeing all of this, there should be a requirement of public accountability where the government tracks data over how these decisions are made and the documentation of them and makes them public without disclosing individual patient information or identities. Finally, beyond all these concerns, there's an overall and overarching concern, which is there needs to be a protocol that's not 20 pages long and full of all sorts of mushy language. There needs to be clear, helpful rules that will be fair, that will be accurate, and that will be understandable so that these actually govern decisions as they're being made. There is a significant risk that no matter what's in the triage protocol, a doctor or whoever is going to be making these decisions is simply going to look at the 4 people needing that critical care bed and the one bed, and will formulate their own rule in their own head and simply decide who they think should get it and rate them accordingly on whatever criteria is to be used. That's not to impugn their ethics or morality. It's just to recognize, as we often do in adjudicative processes, the need for careful constraints to constrain how decisions are actually made. Let me conclude by reiterating that there are several resources you can look to learn more about this. In addition to what's on our website, I encourage you to do a search on the Arch Disability Law Center because they've done some excellent work in this area. I also invite you to visit the AODA Alliance website, aodaalliance.org. Sign up to get our email updates. There's a sign up link. Go to our COVID page, aodaalliance.org/COVID, to learn more about our advocacy during the COVID pandemic, including in the healthcare area. And finally, look at our healthcare page, aodaalliance.org/healthcare, to see about our advocacy not only in relation to the triage protocol, but over years, our advocacy to protect the interests and the rights of patients with disabilities who need accessible healthcare services. I invite you to watch the video of my August 31st presentation to the bioethics table, and I invite you to watch the video I made about a year ago that addresses healthcare barriers pre the COVID pandemic when we had no idea any of this was coming. The most effective way for the Ontario government or any government to address these concerns is to do so in the open. Premier Doug Ford of Ontario committed during the pandemic that the government would be open and transparent in how it dealt with issues during the pandemic, and also committed to protecting the most vulnerable during the pandemic. Well, this triage protocol deals with those who are the most vulnerable, and there is a desperate need for openness and transparency in how this is being handled, and that should begin now. Thank you very much, and stay safe. Stop the presses. Oh man, that's a bit 1970s, isn't it? How about this? Breaking news. Let's have some text up on the screen that says breaking news. Breaking news. Since I recorded this video, we've had some new developments. Welcome to the world of being a disability rights community organizer and advocate. Things keep changing by the minute sometimes after not moving at all. During this lecture, I said over and over that the government had not rescinded the March 28th critical care triage protocol. Well, that's because we asked over and over, and they were told over and over, and they never said they rescinded it. Well, on Thursday, the 5th of November, just hours after I had finished recording this lecture, the opposition New Democratic Party in the Ontario legislature used question period to raise this issue. And we're delighted that they did, because sometimes that's the only way to get action. They asked the MPP handling this issue, asked the government, asked the Minister of Health to commit to withdraw and rescind the March 28th triage protocol and to make public the bioethics table's recommendation. Now, the minister wasn't there that day, we gather, Christine Elliott, so her parliamentary assistant, an MPP named Robin Martin, answered. And she said that the protocol had been withdrawn. It had been rescinded. That's the first we heard of that. The government never said that in response to any of our correspondence or other public efforts to get them to do that. And it's important news if it actually happens. However, the government did not agree to make public the bioethics table recommendations. The most that MPP Martin said in a statement that looked carefully worded to me, they get briefing notes on how to answer anticipated questions, so that could well be what happened here. But she said that if circumstances significantly or considerably deteriorate, the government may make public a new framework for dealing with triage. Well, then Ms. Martin went on to say that the government didn't think that that was likely to happen. We're very concerned on multiple fronts. First, when we saw this statement, while we were delighted that the government said that they rescinded the protocol, we need some proof they really did rescind it. It's not just good enough to say it in the legislature. That doesn't mean it ever gets through to hospitals. So on the 9th of November, on behalf of the AODA Alliance, I wrote the Minister of Health, and among other things, I said, can you please let us know what your communication plan is and show us the documentation of what you've sent to hospitals and so on to let them know. I also filed a Freedom of Information request to try to get that information. Well, just before recording this addendum, I found out that on the 6th of November, 3 days earlier, before filing that Freedom of Information request, the Ontario Human Rights Commission Chief Commissioner Ina Chadha wrote the Minister of Health, congratulating the government on rescinding the protocol and noting that it had been communicated to senior hospital officials. Well, that's helpful news, but here again, the government hasn't told us what they're doing. Had the government not been asked in question period, we might not have ever heard about any of this. And we've been active not only in the regular media and through other efforts like this, but through social media tweeting about this, trying to press these issues. So the government knows full well that we're asking, and we're not telling us, even when they were doing something that we liked. But going further, the problems are not resolved. The government has now created a vacuum by rescinding the triage protocol. They need to let us know what will replace it. If they don't replace it with anything, then frontline doctors might end up making decisions on life and death issues like triage, should the circumstances arise, without having any directions from the government on how to do it. In other words, they could end up doing it based on their own personal preferences or personal biases. This is a very worrisome situation. And to this end, it's totally unacceptable that the government simply said, well, we may release a framework if the situation deteriorates. By the time it deteriorates, it'll be too late for us to have any input. If they send us a framework, there's a real risk that it may have problems that we need to get fixed. We certainly learned that from the first round last March, and the second round when the bioethics table gave us a revised draft of the protocol last summer. So our letter to the minister went on to say that it's important for the government to now make public the bioethics table's recommendations and consult us and let us know well enough in advance what it is they plan to direct doctors to do. The November 6th letter to the Minister of Health from the Human Rights Commission's Chief Commissioner echoed the same concerns about the need to make the bioethics table recommendations public now and to not wait until circumstances deteriorate before the government makes public the framework that would be applicable in a triage situation. Let me just emphasize one other point. In our discussions with the bioethics table last summer, the bioethics table members explained to us that they were trying to get their work done as quickly as possible because it's important to get these issues finalized before the circumstances arise where they're needed. There would be need for training frontline staff on the new regime, the new triage rules, and so on. And we share their concern and respect their judgment on this point. So the government's, and indeed the government's decision last February to get something started in this area, albeit we've criticized it for being secret, was commendable in the sense that they were trying to get ahead of the game. Now it seems the government's policy is not to get ahead of the game and to wait until we're in a potential crisis situation. Well, that's totally not appropriate. And therefore, the challenge facing us community advocates remains. It remains pressing. It remains a matter of life and death. While we've had an important step forward by their rescinding the current triage or the March 28th triage protocol, we remain in a situation of complete uncertainty of what's going to happen should circumstances arise. And this is all being discussed as the daily COVID infection rates keep accelerating. This is a problem that is real and serious. It is not one that we can simply wish away. That's the end of my breaking news. Certainly there will be more developments post-dating my recording of this on November 10th. Please stay safe.